it stops, no one knows. We're going head into the unknown. Na, 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 na.
Well, hello, everybody. Happy Monday, and welcome back to Criminality, or welcome to Criminality if this is your first time here. So thank you guys for being here. We just, I was actually finishing up some stuff to do a Karen Reed live, and then I got these, so I was like, all right, we got to go and talk about this stuff real quick. I mean, not that it's not expected, but what wasn't expected was she actually decided to write like 6 pages of feedback. That's really the only word I can use on what this document is, because she refuses to give them the actual legal reasons, but you guys are going to see it, so I'm not going to get too far into it. Let me say hi to everybody and we can get started. Depending on how long this live ends up being, I may still do a Karen Reed one, but there's no Karen Reed trial tomorrow, so I can always put that in on for tomorrow too. So we'll see, because if we want to talk more Delphi, because this case is, it's frustrating to say the least, and you know, I don't foresee justice coming anytime soon, and that sucks. So let me say hi to you guys, and we'll get started on the latest in the Delphi case, from the courtroom, I should say. So what's up, Fluffy Bunny? What's up, Chris? Hey, Journey takes a trip. Ha! Happy I fought alive. I've missed a few. You caught alive. I had to catch up on replay. You mean of uncalled for negative opinions? I don't know. She just does whatever she wants. She likes to give feedback. Hi, Just Deb. Hi, Kyra. Hey, Carrie. I think I said hi to you when I was reading your comment. Hey, Aaron. Hey, Miranda. What's up, unindicted? Shopping in Meyer and ran out to my car to get my earbuds just so I can shop and listen. I do that. It's so bad. I do it though too. Hi, Mandy. What's up? Hello, Spring. Hey, Richard. Petunia. Lynn, Judge Gull isn't going away. I don't know if that's the end game, but it's definitely not going away right now. Yeah, I will agree with you there. I rescue all the dogs. Simon. Hi, Teresa. Caitlin, look at you, 6 months. Dang, girl. It's crazy it's been that long. Hey, Shaz. Angie, baby. What's up, Scully? Hey, Mother of Dragons. Mother of Dragons. Hi, Chelsea. Hey, Rebecca. Let's hop down here. Hey, DB. Just like Chad Dayball, I called this one. It's like I can see the future and predict such low probability events. I know. We should all just listen to you from now on when it comes to these really obvious things. What's up, Phil? Hi, Princess Megan Elsa. 14 years tomorrow for Kyron Horman. That's crazy too. That case is that's one of those that it's an obvious answer, but they can't seem to get it. Hi, Carrie. What's up, Carla? Teresa, 2 months. What's up? Hey, Francis. Hey, Mickey. Kezchick and Dina. They need to go to the Supreme Court. Well, I would not be surprised if that's where we are headed. Hey, Yvonne. Hi, All Eyes on Delphi. Awesome video. Very good. If you guys are not subbed over to All Eyes on Delphi, you should be. It's a very good video. Was it yesterday? I don't know. Maybe it was Saturday night. I was in San Diego yesterday, so maybe I watched it last night. I don't know. My sleep schedule's all messed up. We had Kaylee had competition yesterday, so I also have to put that video together for her. Hi, Kit Kat. Good afternoon. I guess it is afternoon. Did I say good morning? I don't even know what I said anymore. Hey, Lone Pony. What's up, Pebbles and Marbles? Heavy Metal. Yeah, she does amazing work. Amazing work. I'm so glad she started that channel. So glad. I already have a favorite line in this filing. Okay, let's get to it then. All right, so hi to anybody who's popped in that I did not actually get a chance to say. I don't even know my words. Maybe I shouldn't be live. Well, thank you guys for being here anyway. Even though I mess up my words and stuff. Judge Gull stepped down bribery fund. Fingers crossed. Thank you, Francis. All right, hold on. Let's pull it up. Okay, so first we'll go over the little one. This is her denial order of the motion that was filed by Hennessy, where he was asking for her to take the demeaning commentary out of the order from her written order of contempt, where she essentially says that she could not find any contempt, but that they're pieces of shit, and she's going to send it over to another place to see if they can find an issue. And he had requested for her to remove that, since there's really no legal reason for any of that to be in any type of court order. But she says the court has reviewed the defense's counsel's petition to strike the gratuitous and demeaning commentary and or quote-unquote findings from the contempt order. As the court granted counsel's motion for specific findings, effect, and conclusions thereon, filed on March 12th, 2024, this motion is denied. So essentially what she is trying to say is, you wanted me to give you a reason while I was finding the reasons I was finding, so I did. That's not what he was requesting, but she's like, you asked for it and I gave it to you, and that's how it's gonna go. So she denied that, and she's saying, nope, that order is gonna stay how it is. Now I know, so as you guys all know the rules in my chat, like I absolutely allow any opinions of any of the players in the case, mostly in the court, like the lawyers and whether you think Richard Allen is guilty or not guilty, all those things. I don't allow any type of being mean to each other or opinions about each other. So that's really it's the simplest rule. If you have somebody that you disagree with, just simply disagree with them and move on. And there's people who are in the chat that absolutely disagree with me, and they're still welcome here. I'm okay with that. I don't care. I live in a free world. You have the right to your own opinions and your own choices, but I also have the right to make sure that you guys remain kind to each other. So that's it. Just stick with that, and the mods will take care of the rest. This situation in court, I have tried to do my best at separating this case into like three overall topics, if you will. And I hate to use the word topics because I mean we have two girls that are gone, but three topics. We had the whole situation with the leak. We had the whole Supreme Court, all the legal stuff that happens, which is kind of what we're talking about now. And then we actually have the case against Richard Allen. Those, and the way I've kind of had to put it in my own brain is to kind of separate it into these sections. I do not care for Judge Gull. And it's becoming more and more so all the time. It really is. I just don't. I thought at the beginning of this, when she was appointed, I was like, great, she's got great experience. She's out there advocating for, things in courtrooms that we all want, And now I'm just at the point where I can honestly just say, I just don't like her. Not in this case. She's probably a great mom, great grandma. She's probably all great at all those other things. I don't like her in this case, and I don't think she should stay. Now, that does not mean, and people get this kind of, they like to merge these things together. That does not mean that I think that Richard Allen is innocent. I still, at this point, nothing new has come out that has changed my mind one way or the other, whether I think he's innocent or guilty. I think there's a good chance it could go either way. And I have, once again, still the same essential questions that nobody on YouTube or social media can answer. I need those answers probably from the trial, or we're going to need some more in-depth motions filed on both the prosecutor and the defense for me to have the answers that will satisfy me. That doesn't mean that those answers are needed to satisfy viewers. You guys can all have your own conclusion already. But I just need to make sure that I put that out there, because typically what happens is I say things about how I disagree with Gull or how I agree with the defense, and people are like, she loves Richard Allen and she wants to have his babies and have him move in with her and like weird shit. And that's not the case. So just want to preface the whole thing by that. I am extremely frustrated with this judge at this point, that she's, I cannot fathom a world where anybody, whether you think Richard Allen is innocent or guilty, that doesn't see that her attitude towards the attorneys, and hence Richard Allen, by removing the attorneys he literally asked her for, does not think that there's bias. I cannot wrap my mind around that, but I'm not going to be mean to you if you do. So that's where I'm at with it. So I know quite a few more people have popped in, so let me say hi to you guys. MK, thank you so much for the gifted memberships. That's so cool of you. And welcome to all the new members. C-Dub, hi, good to see you. Hippie Chick. Hey, Ramblin'. Hey, Mar. Let me just see if there's anybody else I can just see right real quick. Hey, U.S. Libertarian. Hey, Crystal. Hey, Gam. Hey, TNT. Lurking as I do housework. That sounds lame. Just hang out with us instead. We're way cooler than housework. What's up, Amy? So, hey, the Royal We. Her signature looks psychotic. Hi, Carla. So that's where I'm at. I guess it's opposite. It's in opposite order. And hold on, maybe I missed what you said. I really hope that she doesn't preside over all of her cases like she does this one, right? I know. I don't know how anyone can say Gull isn't biased when she has proven that she is. You want to go with like appearance of bias, even just if you go with that, like that part I just don't get. There's no way that, in my opinion, she is the right person for this case. I don't think so. I just don't. Hey, Patricia. Hey, PG. Good evening. Good evening. Hey, Satya. Her daughter must have suffered when she was just a girl. Every time she asked her mom to leave the dinner table, her mom's like screamed, "Motion denied. You must sit here until all of your food is eaten. Oh, I will write very nasty things about you to your teachers." That's just where I'm at. Like I said, my opinions are literally just that. They're just my opinions. So you can have your own, and we'll all live happily ever after. Okay, so I did pull up the motion to disqualify. So if there's anything in here that we need to take a peek at, we can. I think the first Frank's motion set Gull off. Her impartiality has been affected and her ego won't allow her to see that. Kevin, I agree with you. Now that we have, I think that they bugged her probably before. Like they were like, oh, and she's like, oh, these guys are like kind of irritating. They're like not doing what I think they should be doing, kind of thing. But then I think with the Franks, I think the Franks, and then with the immediate leak of these photos, I think she was just pissed, and she was like, you guys aren't going to be here anymore. But I do not foresee a world that the defense team filed the motion for her to disqualify expecting that she was going to disqualify herself and that they don't have another plan in place. That's where I'm at. It's all because Gull doesn't have a sunroof. She's pissed at life now. It's probably true. She probably needs a sunroof. And that's an inside joke. So people are like, what the hell do you guys keep talking about sunroofs for? Okay, so the court has reviewed the defenses. Hold on, I think I made it too big because now it's like off the charts. There we go. Okay, the court has reviewed the defense's second verified motion to disqualify judge and request for findings of fact and conclusions of law upon denial of this request. If this court denies this request, filed May 17th, 2024. As Trial Rule 52 is not applicable in criminal cases, the defendant's request for findings of fact and conclusions of law is denied. So Neely versus State and Davis versus State. The court, however, will address each of the defendant's allegations in this order. So the defendant claims the court directed the Carroll County Sheriff to ignore a subpoena. The court directed an email to counsel on June 14, 2023, regarding the witness refusing to cooperate with the service of the subpoena and demonstrating a willingness to fight the deputy attempting service. The court requested a report of the witness's refusal to cooperate and be transferred for the scheduled hearing and forwarded that report to counsel when it was received. The decision by the deputy to leave without the witness was his and was not directed by the court. So that's Robert Baston, who was supposed to testify back in June of 2023. They state that this deputy literally was in contact with someone who was in contact with her. I mean, or he was directly in contact with her. I'd have to go back and look at the motion, which is why I pulled it up. So let's just do it real quick. Does she do it in order? Hold on. This one's too big too. It's like taking up the whole screen. This is 40 pages. Maybe I'll just search. Let's see. Let's do inmate. Why don't you want to search? Here. The deputy went to transport the inmate to the hearing. The inmate became uncooperative. Carroll County's Chief Deputy Tobe Lesenby contacted Judge Gull about the situation, and Judge Gull told Deputy Lesenby to leave the inmate there if he did not want to come to the hearing. Okay. So she's saying no, that's not what happened. The deputy chose to leave, and that he wasn't directed to do that by the court. Well, where the heck? I mean, I don't. They're just like, oh yeah, Tobe said this. Tobe has basically been deposed like at least 2-3 times at this point, and he's saying that that's what happened. And she's just like, no, that's not what happened. Yeah, I don't know. Okay, so the defendant claims the court engaged in an ex parte communication with the Carroll County Sheriff regarding the defendant's housing, transportation, and safety during jury selection and trial May 13th through the 31st. These communications were administrative in nature and did not address any substantive issues. The communications were directed to where the defendant would be housed during the trial and who would be conducting transportation. This is when Liggett was being deposed, and he said that he's the one who actually ends up essentially telling the defense team where Richard Allen's going to be for the trial. Nobody really ever told them but Liggett. All right, let me see what you guys are saying so far. I would like a new judge, but also worry the next one would be worse. Diener's refusal was good, but getting Gull was a bad trade-off, right? There, like when I was little and I would get mad at my mom would tell me to take me to her the mommy store and trade her in. And I would cry and I'd say, but what if I got a worse mommy? I would never take my mom to the mommy store now, but that's what she used to tell me when I was mad at her. And that's what I think of. I'm like, what if we took the judge to the judge store and we got a worse judge? They're usually more upset about their sister. Yeah, that's what I'm like. I don't understand that whole thing. Like, that doesn't make sense. Like, Tobe is the one saying it. They're not just like, oh yeah, Tobe called her. Like they're the ones. Tobe is the one saying that he called her and she said not to worry about it. Yeah, ducking felonies. Surprise. Liggett was like, yeah, I just don't totally feel like driving that far. So guess he's got to be in prison for 2 years at least. Right. Every time an official says something that implies inmates or visitors have any say what inmates do when they do it or how they do it. I go, right. Yeah, so the deputy leaves because the guy's going to fight, but you don't think that there's any. He is, and Robert Baston's actually convicted, so he is a prisoner at Westville. So he is under the control of the prison. So he just goes like, I'm going to fight you, deputy. And the deputy's like, oh, no, I don't want to fight. I'm out of here. And then Tobe is like, it's okay, man. I got a hold of the judge, and she said it was cool for you to leave. Like, that doesn't even make any sense. It's just silly. So the court did not notify counsel where defendant would be housed during trial, as he is under the safekeeping order in an email, the court did notify counsel where defendant would be housed during the trial, as he is still under the safekeeping order in an email, but did not inform counsel of the communication, as nothing substantive was discussed. The court has set the defendant's motion to vacate his safekeeping order for a hearing, but was required to cancel the hearing upon the filing of this pending second verified motion to disqualify. Counsel claims that the court invited the state. Okay, hold on. So she does every one of them in a different paragraph. Hey, Oz, what's up? It's like Richard Allen is Gull's middle child. She's just like, fuck him. Yeah, and DB says, if they wanted him there, he'd be there. LOL. But since he's a defense witness, he'll literally cut out the entire legal process. Yeah. So when all these inmates that are set to testify at the trial, they're just like, sorry, we're not coming. We're going to fight you. And they're just going to be like, okay, well, they're not going to be here. I know. That's why I'm like, that's the silliest thing. So if they threaten to fight, they don't have to go. That's essentially what she's saying, was like, if they threaten to fight the deputy, then that's it. Like, they don't have to do it. They don't want to do it. They're like, I'm not going to solitary. I'm going to fight you. And they're like, all right, fine. No solitary for you. Yes, exactly. Yes, they are meant to be in the business. They are in that business. That is kind of what they do. It's kind of like their whole purpose. But she simplified it. That's fine. Okay, so that is what it is. Like I said, at the end of this, there's no way that the defense team put this motion in and expected her to approve it and just go, okay, I'm going to go away nicely. There's obviously a long game here. We just don't have all the pieces yet. But this is, in my opinion, was expected. They wanted the actual conclusions of law in there so they could have the reasons to take it to the Supreme Court. But she's like, nope, I'm not going to give you those. So those had to figure it out themselves. Hi, honey.
Hi.
Is that your candy salad?
My candy, and I bought this.
Nice.
With my tickets for history.
Good job.
Do you want to see the picture?
I do. My daughter just got home from school, and her friends made a candy salad today. So I get to see all the fun stuff. Give me 1 second, guys. You guys all brought sour candy.
That's the point.
Oh, it is? I thought it was just gummies.
No, sour.
Oh, okay. They made a sour candy salad.
Candy.
Okay, sorry. Jeez.
We watched
not in the know.
Wally.
I know.
You know I would text him all the time. Can't believe you went to come get me.
I wasn't going to come and get you. You have 1 day left.
I watched a Lego movie and
The Lego movie?
Yes.
That's a good movie.
No.
What?
But I was able to eat my candy. And I talked to 4 tables around me.
Okay.
And we got yelled at a couple times, but
You have 1 day left.
Okay.
You'll survive.
They were like throwing things, and then she was like, you too. And we were just like, okay.
All right, I'll come catch up with you in a minute. I'm live. They don't want to hear about your candy.
Yeah, they do. Who doesn't want to hear about my candy? Oh, and I cleaned out my locker. And my bag's really heavy.
It was C-Dub, and she did wear it, and it was a little snug, but it'll last the rest of this season for sure. Yeah. Mandy says she wants to hear about candy. DB says that's his favorite kind of candy. I searched for hours to find how this whole catastrophe is even possible. I like Hippie Chick says I like learning. I'm curious about the candy salad. Essentially, they just put a bunch of candies, sour candies, in a bowl and mixed it up, and then called it a salad. So I guess that's like the cool thing to do now. And then they all split the bowl, so they all shared the candy. But they only have, all my kids are, their last day of school is tomorrow, so the countdown is like literally official. We're at one more, and they're all very excited. All right, sorry, off track. Let me see. Okay, we went back up here. So they were asking for the conclusions of law, and she's like, yeah, no, but I'm going to give you. That's why I called it like feedback at the beginning of this, because that's how I felt it was. We do want to hear about the candy. Hey, Fiend. My daughter made a candy salad at school last week. I didn't know that was a thing. Yeah, apparently it's just how it goes. Everyone just denies shit. Hey, for Pitbulls, they tased RA for nothing. They tased RA for a lot less than him saying he wasn't going to go to a hearing. Could you imagine if he said that? And he's not even a convicted prisoner. All right, so now I got to figure out where I was. Okay, so this is about where he was going to be for trial. She said, yeah, she had these communications, but they weren't anything that needed to be actually done altogether, or they needed to be notified of these conversations. It was literally just about the transportation and how it was going to happen. And so she let them know what the ruling was, or what the order was, and where he was going to be, and that's all she needed to do. Hey, Just James. Your youngest graduated? Oh, True Crime fan girl. I don't want any of mine to graduate. I'm dreading it. I mean, I want them all to graduate. I just don't want them to be that age where they graduate. Hey, Johnny. Of all the awful things that apparently have happened in that prison to the detriment of Alan, yet the one thing his defense wanted, they might have helped him, and the prison is like, sorry, no can deal. Sorry, ain't happening. Okay, so the next claim is the counsel claim the court invited the state to limit defendant's Sixth Amendment right to present a defense. The court has always required counsel in all criminal cases to follow the law relating to third-party perpetrators. The court reminded counsel of their obligation to follow the law in the court's email of April 28, 2024. No, she essentially says that she knows the law. She knows the law, and that they haven't done it. That they haven't done any of that. No, I don't want my kids to drop out of school, DB. Stop changing this subject. No, I just don't want them to get that old. I like them here. I like them with me. Hi, Kathy. Hi, Kelt. So, and this is also interesting that she says this, because in the court hearing on May 7th, she's like, if you guys would have just told me you needed more time, I would have given you more time. And I'm like, no, you literally told them in the email that you know the law and that they don't meet the requirements. But they haven't had a hearing to be able to meet any requirements, and you won't have a Frank's hearing. You just keep denying them, so they can't actually give them anything. So funny. Okay, my bad. So counsel claimed the court has disparaged them and ruled on defense pleadings without hearings. The court's comments about counsel's performance were documented in the court's order of April 30th, 2024, regarding their handling of discovery materials. If pleadings on their face are not supported by law or admissible evidence, judicial economy does not require a hearing. The whole bias thing comes from the fact that she's going to offer a hearing to Librato and Scremin and say, hey, if you're going to adopt the Franks, let me know. We'll schedule a hearing. But as soon as they come back and they're like, okay, we'd like a hearing, she's like, no, thank you, denied. So I think she's missing the issue there, but maybe I'm reading between the lines. A lot of sites have RA already guilty. I know they do. There's not enough for me. And as I try to like kind of point out is like our opinions online are just our opinions online, but there are 12 people who are going to sit on that jury that are going to ultimately make a decision, and they're not all going to come from the same line of thinking. They're not all going to look at it and go, oh yeah, we agree with this YouTuber, so let's go this way. You know what I mean? Like that's not how it works. So our opinions are just our opinions, but those 12 people may actually see things the way that I see things, or may see things the way that you see things. Hi, CW. Hi, apple bottom jeans. The boats with the girl. At the hearings of safekeeping, Gull was like, sure, your motions had a lot of good case law, but you're not any Indiana 74th Circuit Court case law. But her motions, she's all case law, schmace law. And she's like, I don't have to do it. I just can tell you to if you want to. How many weeks is that Karen Reed trial getting? Well, they are currently on the 6th week. This is week number 6, but it's kind of funky because it's actually today was only day 19. But she has it scheduled, I think, for 7 or 8 weeks. But if it goes longer, she's not like, nope, you guys are done. Allegations that the court has treated the prosecution more favorably than the defense are unsupported by any admissible evidence provided by the defense at the March 18th, 2024 hearing. Are more than the defense are unsupported by any admissible evidence provided by the defense at the March 18th hearing. The court was notified on May 20th of an inquiry by the Indiana State Police to the court reporter via email on May 9th regarding ex parte communication received by the court from Gary Boudet, which was previously provided to all counsel. The court is unaware of the extent of any Indiana State Police investigation. Okay, hold on a second. Allegations the court has treated the prosecution more favorably than the defense are unsupported by any admissible evidence provided by the defense at the March 18, 2024 hearing. Okay, so that's all the stuff that they probably had like Skip on the stand for, and they had the like the thumb drives, and it had all this stuff on it, but she was like, I don't really care about it, I don't want it. The court was notified. I know, right? Low point, I'm like, what? This doesn't even make any sense. The court was notified on May 20th, 2024. Okay, so 2 days after that hearing, of an inquiry by the Indiana State Police to the court reporter via email on May 9th. Okay, so the ISP reached out to the court reporter via email on May 9th regarding ex parte communication received by the court from Gary Boudet, which was previously provided to all counsel. Does this make any sense to you guys? And is there anybody who can break that down where it makes any sense? ISP contacts the court reporter via email on May 9th regarding the ex parte communication received by the court, which was already put out to the public or to the counsel. The court is unaware of the extent of any ISP investigation. All right, hold on. Let me see if I can find. Let's see if I can find anything in here. The defense provided evidence. So this is back to the actual motion to disqualify. The defense was saying he was being investigated. Is that what it means? Yeah, I don't. But they're saying that there's an actual email from the ISP to the court reporter. Oh, so ISP got an email and they sent it along to the court. It doesn't make sense no matter how many times I re-say it. Okay, let me go back to the motion to disqualify and see what they said about Gary. At the March 18, 2024 contempt hearing, the defense provided evidence to the court that the Carroll County prosecutor, Nick McClelland, interacted with a social media content provider named Gary, aka Fig. The evidence was in the form of emails, including an email in which Fig claimed that McClelland had requested Fig to erase their communications. Okay. Is there not another one from... The defense provided evidence that other leaks occurred in the case, implying that those leaks could have came from Nick's office, required the defense to cooperate in the investigation. Judge Gull seemingly has no interest in similar allegations attributable to the prosecution. Judge Gull's actions, as referenced in the various paragraphs above, create a rational inference of bias against the defense and in favor of the prosecution. Okay. I'm trying to put this together to see if I can make sense of it. Oh, dumb, Kay, you're right. Thank you. Thank you, Kay. Yeah, no, May. She got it on May 20th. So what the hell? That even makes it make less sense, no? Is she saying that the ISP only got involved in May, well after the hearing? If so, that's different to what the defense are saying. They say she's been employing double standards. Darby. Okay. So the allegations from the March 20, that sentence right there on its own, on its face, absolutely makes sense because she did not allow any of that evidence in, which is fine. So I get that. Okay, so I get that. Now this whole next part. The court was notified on May 20th, and thank you, Kay, for pointing that out, 2 months later, of an inquiry by the ISP to the court reporter via email on May 9th regarding ex parte communication received by the court from Gary Boudet, which was previously provided to all counsel. The court is unaware of the extent of any ISP investigation. Okay, so in May, the ISP is now investigating. That's what that sounds like to me. If we separate these two, it sounds to me like ISP is investigating whether Nick McClelland was leaking information to people like Fig Solves. That's what I'm picking up. That's how I see that. If you'd separate those two. But at the time, she wasn't aware of it. And now she's still, at this point, when she writes this, unaware of the extent of any type of ISP investigation. Okay, does that make sense? That's the only thing that can make sense out of this. Hi, True Crime, whatever. It's good to see you. I know, I'm like, this whole paragraph, I'm like, I'm not sure. That's the only thing I can come up with, is that this should be two separate things, but maybe coincide because it's the same topic. Oh yeah, I'm supposed to be able to read between the lines, Kelt. Shoot, I forgot. Well, I'm not a lawyer, so do I have to read between the lines? Why did she put in the investigations by ISP? I don't know. But it does seem by this paragraph that ISP would be investigating something or asking questions about something. But so far, all she knows is that they asked for the ex parte communication that she's already provided to counsel, which is actually already public anyway. We went through that. He was the first one to email in because he was named in that filing, which still doesn't, I mean, it doesn't do anything. He could have just given the information to Nick or to the prosecutor or to the defense team. But I think I'm not gonna speculate on why anything was done. Right. Why would the ISP need to contact the court reporter of communications? Well, the court reporter was also somebody who was accused of having conversations with Fig. And she was accused like while she's in the courtroom too. Gull is leaking ISP's investigation. That's interesting. So it seems that they're looking into something. How far they're looking into anything, I don't know, and apparently the court does not either. But that is a really oddly worded paragraph. So I can only relay to you how I'm interpreting it. I have no idea what she means when she writes this. I really don't. So the defendant blames the court for the ex parte pleadings, which were inadvertently directed to the prosecutor. The defense staff filed pleadings and marked them as confidential, apparently unaware that the confidential marking makes them available to the state, but not to the public. Counsel staff contacted this court staff and were advised that the statewide Odyssey case management system, not DocsPop as alleged in the pleading, has a distinct process for filing pleadings ex parte, as opposed to confidential. The court did email defense counsel a tutorial paper, oh Jesus, how condescending, authored by JTAC explaining the process. Since that communication, defense counsel had no issues with their staff properly filing ex parte pleadings. Okay, she might want to send it to Nick too, because he doesn't know how to file anything like that either under any type of confidential or seal. But that's neither here nor there. The bigger part of this to me is the other attorneys that are have limited appearances that are actually on the case could not access these documents when they came out. Now, can I prove that? No. Can they prove that? Apparently, they say they can. So they believe that somehow this ex parte filing, which is, I'm sure anybody who follows along with the filings probably remembers, the filing at that time was about like expert witnesses and a psychologist that they were going to use. And then Nick went ahead and put in a motion to talking about this psychologist. And the defense was like, "What? How do you? Wait! You shouldn't know anything about this. Like, you should not have any idea who that person even is yet. This is all ex parte." So the other attorneys, not the defense attorneys, the other attorneys that were still filed with a limited appearance, have said that they didn't have access to that filing. They could not see that ex parte filing. And if any lawyer on the case could, they should have been able to. So the accusation is that possibly the court clerk, court reporter, somebody in that courthouse gave this filing to the prosecution. That's the accusation. Obviously, we can't prove it one way or the other. We can just go with what we think could have happened until we hear more about it. Hi, Susan. Holy crap, I took a nap. I just woke up. When the hell did she file? Today. Yeah, today. I know I was going to do Karen Reed live tonight, and then this popped up, so here we are. Their defense, they need to know how to file ex parte motions. Gull doesn't know what she's talking about. Well, they'd filed ex parte motions before that I don't think had any issue. So that's also another surprising thing. Did something change in their systems? I have no idea. I find it interesting that ISP contacts by email rather than in person if involved in active investigation. That's true too. But maybe they just wanted that email, and they're just like, "Hey, court reporter, can you just give us that email? Because we know it's already on the record. We just want a copy of it." Maybe they didn't want to go digging around for the PDF or something. I don't know. So they're just like, "Can you send it to us? We'll just see if there's anything to this." I have no idea. That was totally out of left field. And then not only is it out of left field, she makes that paragraph so fucking confusing that I don't know which way's which. Fig appears again. Yeah. Hey, Criminal Network. Didn't the company that provides the filing services for the court tell the defense that the clerk's filing was filed wrong? Not surprised, ISP emailed the clerk, but not the company about it. Well, we don't know. Maybe they did file the company about it, things too. Even the judge says, I don't know the extent of this. I don't know the extent of this investigation or this, what their interest is in this information. It's called gaslighting. Yeah, it's called just word salad to confuse the shit out of you so you have no idea what she's talking about. Is she covering for Nikki Hughes, the one reading the ex parte? Well, there's definitely some type of problem with the ex parte filing system. So, here's a possibility. Whether it's true or not, I don't know. But because neither of these guys are practicing attorneys in her courtrooms in Allen County, just for the same reason we were talking about when we did that read through the other day of why Rosie would not just automatically know she has a firm end date, is because he doesn't have any trials in front of her. So he's used to his county and his judges. So maybe do they use something different there? I wouldn't think so. I think that the state of Indiana would use the same thing. See, I disagree with that. Like I was just saying, because the problem I'm having is they had already filed ex parte motions, and those were fine. The other attorneys that had filed limited appearance to have access to these court docs could not access that ex parte filing. And then it was supposedly confirmed. That's why I'm like, I don't know. And I don't think anybody can say really one way or the other, because nobody has access to the system. But it's definitely sus that they had no issues before, they had no issues after. Supposedly other attorneys that should have had access if it was filed that way didn't have access. Did he just not put Peggy? Did he just not put the other names in his motions? Maybe. Maybe he's just like, oh yeah, I've totally been reading these all the time. That wouldn't surprise me either. I don't remember that, but I wouldn't be surprised. Hey, Tammy. But that whole paragraph it's kind of got me. I'm gonna have to go back to it. Accusations of violating rules on access to court records have been completely explained and dealt with, including by the Indiana Supreme Court in the first writ of mandamus filed by the defendant. Right, which is still not accurate. She was supposed to fix it, started to fix it. The Supreme Court says, okay, it looks like she's working on fixing it, so we're going to let this one drop, but then she still doesn't ever fix it. It's still not right. Counsel claim their motions are treated differently than those motions filed by the state. The court has set hearings on pending motions which have now been continued due to the filing of this motion to disqualify. When defendant files pleadings, the state is entitled to file a response. The court follows Trial Rule 6 regarding time and gives the state 20 days to respond. Hold on, the state is entitled to file a response. The court follows Trial Rule 6 regarding time and gives the state 20 days to respond. Defendant is also given 20 days to reply to the state's responses. Once the issues are closed, if a hearing is required, one will be set. I thought it was 10. Didn't we just talk about this? Hi, babe.
You want to make one?
What are you eating? Are you eating them?
Yeah.
Oh.
There are 2 left now.
Good job.
I ate the same.
How was school?
Good.
Good.
I picked the one with the Oreo.
Okay.
Everything was good. We didn't even have to do homework.
You don't have to do any. You didn't have to do any schoolwork.
We could lay down.
You have to lay down.
We could.
Wow, that's nice.
Like that.
Okay, I love you, babe.
Get back to work.
Okay, I'll get back to my work. Okay, the defense has so many avenues to discuss, they failed to address half of them. Huh? Because they probably have so many to discuss. They're just like, we don't even know which one to pick now. I think he put it in writing too. I do. Now that you said it, I kind of vaguely remember reading that, but I don't I don't remember the quantity. I guess, but I constantly find important emails in junk and spam, so maybe that explains the time difference. A couple of those motions Nick mentioned were not ex parte motions. They were just discussing ex parte procedure and stuff. The LE were incompetent. I'm just struggling with this whole case right now. I'm struggling with all of it. Judge went rogue, and now we know for sure. Either way, either grants them for the state right away or never rules at all on things. Yeah, I bet we could probably go back through here and find quite a few filings that they don't give 20. She doesn't give 20 days on. So, I mean, I think that would be. I think we could probably even just pull up like Sleuthy's list of all the filings and the response dates. I bet she probably has them that way, because I can guarantee that there's no way she's let a few of the state's motions go to 20 days for a response. McClellan took more than 2 months to file a response to RA's petition to let bail. Well, yeah, he was charged with homicide. He was charged with murder. They weren't giving him bail, though. I don't know where that $2 million ever even came from. Kids after my own heart. I want to go lay back down again. I know, no homework, yay! McLean said he could see every filing that was erroneously filed as confidential instead of ex parte. Thank you, Candace. Yes, I believe that. They're covering for somebody. Now, when Nick withdrew his motion that didn't mention the ex parte, and his excuse was he'd read others. Yeah. I have Apophis. Francis, kids drive us so far forward. I have 5. I would have had more, but then I got old and I was like, nah, no, my body doesn't want to do that anymore. Has anybody seen the psychic Angela Thomas interview on Paranormal from 3 years ago? I know, is that the one with the guys? Because that's the only paranormal thing that I quite remember from 3 years ago. It was the one with the guys, and do they interview her on there? The one with the it's like, shit, my memory isn't working. Is that the one you're talking about, Criminal Network? All right, let's see. The defendant asserts that the court ignored his request to set aside 2 weeks for the defense case while refusing to set time limits on the prosecution. On March 6th of 2024, the defendant filed a motion for a speedy trial. The court granted that motion on March 7th and set the case for speedy trial May 13th through the 31st. On April 30th, 2024, defendant filed a motion for a pretrial hearing, which the court set for hearing on May 7th. At no time prior to the May 7th, 2024 hearing did defendant advise the court that 3 weeks for trial was inadequate. That's not true. We actually literally just read that. We just read that he does say that he wants more time, and that the longer the trial is pushed out, the more time it's going to require. That's exactly what Rosie said. I'll pull it up. At no time prior to May 7, 2024, the defendant indicated a belief that 3 additional weeks could be added to the trial without notice to the court, witnesses, and more importantly, without notice to the potential jurors. He didn't ask for 3 additional weeks. See, this also goes back to the whole ex parte communications between all of them that were off the record conversations between all of them, because they were having these conversations like over the phone and whatever else, and so nothing was on the record. And Rosie's saying, I told you back in October that we were going to need 15 days. Now, the June 15th hearing that we just read through the transcript of, they're talking about setting the trial dates, and that's when they set the January trial dates. And he tells her he's going to need more time, that he thinks the whole trial is going to need more time. Hold on. Okay, let me see. I watched one saying the name from the spirit box, Steve. I think that's the one that I'm talking about too. I kind of remember that. It was Paranormal Zone TV. Spirit boxes, the state smoking gun evidence. The host was Noreen. Okay, I'll take a look at it. I don't think I've ever seen that one, Criminal Network. Did the interview pre the 136-page memorandum. Okay. For sure it's a competition now. Where Gull is telling Auntie Bev, hold my beer. I think Auntie Bev's doing a much better job. And I try to give that thought process to Gull because Bev was very kind of anti the defense, anti a lot of what the defense was doing in the Karen Reed case throughout pretrial hearings. And I'm like, but during trial, she seems to be doing a great job. She seems to be very fair. I mean, she's got a couple things that I'm like, but who am I? I'm just a person watching the trial. And let us not forget that they got the hearing because the defense filed a response to the state's motion in limine and said, let's have a hearing, and she then set one. Well, this is my problem with that, is they didn't have the knowledge that the court was going to set a bookend end date to the trial. As Rosie says in that hearing, like, I've never experienced that before. Like, I'm not surprised that they're different. I'm just not. Like, different courts the judges have the ability to do what they kind of choose to, like we see here. So she has that ability. And so people who normally would be like trying a case or defending a case in front of her may know that. Other people who have done 20 plus years of defending cases in other courtrooms where there never has been an end date. So even if she sets an end date, why would they think they need to fight about that or to request for more time or anything like that? I totally see this as the lack of communication and the lack of transparency that's happening in these courtrooms. And I blame that on the fact that she does not like having these attorneys around. She does not want them in the courtroom. She does not want to deal with anything that they have to say. She doesn't read their motions. And you guys can try to convince me till you're blue in the face that she read that Frank's. I'll never believe you. And not until she can start quoting me some pages. Other than that, I'll never believe it. I just don't think she ever did. That's why I feel the way I feel about Judge Gull presiding over this case. The defense team has only their incompetence to blame for their misfiled ex parte motions. It's a statewide filing system, so they can't blame ignorance of local rules. Well, they can, because she's the one who set particular rules about how Jody was supposed to be putting things on the record. Correct? And how things were supposed to be being filed when it came to creating her own website. You tell me that that's a statewide website that anybody can access court filings, and then I might go with you. But I'm telling you, things that she has done already when it comes to the filings in this case are unprecedented. They're not normal. So it creates confusion. And if you don't have communication, then confusion proceeds to take over. And that's where I feel like we are now. And you can say that you think it's the defense's fault or Nick's fault. Ultimately, at this point in this quote unquote game of this case, in this trial, it's her fault. She has to be the one that sets these things in stone and says, this is how we do things. This is what we're doing. Not all willy-nilly, like, well, we'll put these 140 on this website over here. I'll stick like 10 of the last 20 over here on the CCS. That's causing problems. So it's going to cause problems for all of them. And we see that in the May 7th hearing when Nick's saying, hey, judge, I filed this motion, but I don't even know what to do with the exhibits. I don't know how to file them. Can I just hand them to you? Because I don't know how to mark them, because they're all confused. And the person that's confusing them is her. So, and this is and I could care less about Nick McClellan when it comes to being the prosecutor on this case. So this isn't a personal, this is her job. This is what she's supposed to do. She's supposed to make sure this trial proceeds forward without all these fucking hiccups. And she's not doing that. I said that when they set the trial date for May and they set no hearings to go over anything. She set not a single hearing to go over any type of motion. Not like, hey, here's your deadline to make sure that you guys have all your motions in limine in. Here's the deadline for XYZ. Here's the deadline for this. We'll hold a hearing, closer to trial on these types of things. So make sure you have all of this in. Like, that's what her job is. So anybody who just doesn't see that, for me, I feel like you need to go watch other court cases because that's what they do. Koberger's case isn't even set for trial, and right now they're talking about it being in 2025. And that guy has a hearing on the books like every other Thursday until trial, and will add more if needed and cancel more if not. Judge is a judge. Yes, he is. John. Oh my gosh, Judge John Judge is his name. So this is where I'm at with her, and this is my frustration with her. Is I think that she's not doing what's necessary. I don't think she cares what happens, and maybe that's because she's got too much on her plate. I don't know. I'm not confusing that. I'm not confusing that. The attorneys are confusing it. That's why my opinion is that she is involved in some type of like shenanigan. The court removed the defense counsel incorrectly, or the case would have been over, but Nikki wasn't going to be ready for trial. Then the strategy to leak the documents, blame the defense. Yeah, keep going, just delay. Jerry Holman started the entire mess. I think their investigation just in itself started the entire mess because that was messy. Richard, I just thought her peers would point out how impartial she is, and that's it. Yeah, that's where I'm at. Like, they don't know how she wants things, where she wants things put, and how she wants it, and then she just blames. She doesn't take any responsibility for it. When technically she's the one who's like, hey, create all these things so we can put them in all willy-nilly wherever we want to. All right, let's see. Okay, we read this one. But this is not true. He does say that. Let me pull that up, actually. I think I might still have it right here. If I don't, then I'll go back to reading this one. I think it... Nope. Is it this one? Nope. A part 2. Hold on, I'll find it really quick. It's right at the end of this. Let's get it to load. Hey, Hammy. Oh, and 4 Pipples. You're funny. I've done well. Oh, I wish you could see that it doesn't do well. And any proceeds go to the 3 children who you hear constantly on the channel. FYI. I'm sorry, but she's crooked. They threatened her or something. I know people have thought that like maybe there's something that they're holding over her. She decided it was time for transparency once the alleged confession was a thing. Low-key shocked she denied. I'm surprised that she, well, I guess I shouldn't say, surprised isn't the right word. She obviously knows that there's more going to happen after this. She's not going to stop. You know what I mean? Like, this isn't, like, the defense isn't going to just let it go and be like, okay, well, she said no. Like, she knows that they're going to have to continue on and figure out something else now, whether it's an original action, an interlocutory appeal, or something. Yellow Jacket posted on X that Gull either lied or threw Sheriff's Deputy Wasowski under the bus and called Sheriff Lesenby a liar to save herself. Have we read that yet? Yes, we read it. I think you weren't here yet. It's just like taking forever to load. It's like, don't go too fast or I can't handle it. Why is it taking so long? This is dumb. It's like if I scroll it, it likes that better, apparently. Okay, so here we go. Pick trial dates. Dun, dun, dun. So she says, I assume 2 weeks for trial. I don't know how long. Mr. Rosie says, I would say that's like easy. Definitely going to be 2 weeks. And she says, like, easy 2 weeks or 3 weeks? He said, McClellan says, yeah, I would say that's probably, Mr. Rosie says, we need to plan for 3 or more. And the court says 3. And Rosie says, I think the longer this gets pushed out, the longer the trial's going to be. So she's literally stating in that order that he's never mentioned this before. So we know that he says he mentioned it on the phone with her in October when they were supposed to go to trial in January, which we don't have access to because it's an off-the-record conversation. But we know for certain, he tells her here, the longer this gets pushed out, the longer the trial is going to be. He already stated we need to plan for 3 or more. Is there anyone else in this chat who thinks this is a 2-week case? I don't. So they planned for, technically, for what, 15 days, I think we decided it was. Let me go back. I actually calculated it. I think we had 13 days. 13 days after jury selection. There was no way. I could not see that, ever. Gull bragging that she gets complex trials in no time is not the flex she thinks it is. I know. She's like, I've done this type of case. I've done that type of case. All right. Let's go back over. I think I stopped in the middle of this. On the search, the court ignored his request to set aside 2 weeks for the defense case while refusing to set time limits on the prosecution. On March 6th, defendant filed for the motion for a speedy trial. The court granted it. April 30th, that, and then when it had no time prior to May 7th hearing, did defendant advise the court that 3 weeks for trial was inadequate? Untrue. We just showed that. He absolutely did say that. At no time prior to May 7th did the defendant indicate a belief that 3 additional weeks could be added to the trial without notice to the court. I don't think he was asking for 3 additional weeks. All he was saying was that he wanted to have, what did he say, 2 weeks to begin with, and then somewhere it said 15 days. I don't remember what conversation that was, though, now. But that's including what he would have already had. I don't know. Could be added to the trial without notice to the court, witnesses, and more importantly, without notice to the potential jurors. While the court agrees a continuance of the trial is harmful to the defendant and to the state, it could have been avoided had counsel communicated prior to May 7th. Counsel represent they notified the court on or about October 4th of 2023 that they would need 2 weeks to present a defense. But the court has no record of that communication. Son of a bitch. Of course not. Of course not. I had this issue back when they were doing this stuff, is having all of these conversations, like, and I get it, like they're all grown-ups and they should be able to have these conversations. And other attorneys that I've watched, they're like, yeah, we've had conversations like this. These guys don't like each other. So now it's like, well, I don't remember that. And so too bad. I don't remember having that conversation. Counsel's assertion that between all defense counsel with a combined 70 years of experience, not one time have they been told that a trial would absolutely end on a certain day and not go any longer is irrational and unreasonable. What? The court is aware its colleagues across the state routinely give trial dates that begin on a set date and end on a set date. Yes, they give dates, but they typically run them longer. Like, and I get it, Bev's not in the same one, not in the same state, but here we are, watching that trial, and she's like, okay, you guys, how many weeks do you need? Lolly says, I need 4. Defense, how many weeks do you need? Okay, I need 2. She says, okay, let's do a week for jury selection and add a week on for good measure, like just in case things don't go as quickly as we thought they would. Here she's like, no, too bad, so sad. Yes, but she's taking this in a context that that's not how it was meant, and she knows that's not how it was meant. Like, you don't just say, okay, trial's over. You show me a trial that when that end date comes up, that they're just like, okay, you literally have 5 more minutes, attorneys. That's it. You're done. Last day of trial. Let's get her done. They don't do that. The court is not required to guarantee equal time for both the defendant and the state. That's true. The court is required to guarantee sufficient time on the calendar and sufficient notice to jurors and the parties to present their case, however long it takes. Okay. Had counsel notified the court within days of receiving the March 7th court order setting the case for speedy trial that the time allotted on the calendar was insufficient, the court would have immediately rectified the situation and extended the trial to May 13th through June 14th. Trial is now set for October 14th through November 15th, as requested by the defendant. Counsel accused. Okay, I gotta stop here. Like, that's just silly to me. I wish I had that one handy. That one that has the email exchange between Rosie and Judge Gull that she gets pissed off about. I don't think I have that one handy. I'd have to probably dig for it. All right, let me see. Everyone is keeping it civil thus far. Please stay the course. Yeah, for sure. Why would a judge whose only interest should be in fairness even consider limiting the time for either side to present their best case? Right. Criminal, now you're not going to get booted. What you talking about? I love your channel. Calls Liggett to the stand. Goal. Good enough. Good enough for you? There you go. Done. There he was. That's Liggett. That's what he is. PSA, if you're related to Gull and you have family beef with her, I hope this whole thing is validating that Gull is just a gaslighter. I think that's a ridiculous comment. When he literally told her she didn't change it. She didn't change it. When they were literally talking about it, and she doesn't change it. We need to plan for 3 or more. 3? I think the longer this gets pushed out, the longer the trial is going to be. Well, that's on y'all. What about January 8th through January 26th? Understanding the jury selection will take place up in Allen County. Like, he literally is telling her, I think we need 3 or more. And she's like, 3? Okay. She said 2 or 3. And then he says 3 or more. And so she goes, okay, 3? Like, perfect. And then, hold on. Oh, where is that one? May 7th. Hold on. Let me see if I can find this. where she says, so she says he doesn't even mention it. Here's another issue. This is just a smaller issue, but still an issue nonetheless. That he doesn't mention it until the May 7th hearing. But in the May 7th hearing, she's saying that he mentioned it on April 30th. Obviously, still not enough time, so it's not as big of a thing, but it's not the time she's saying she required. Where is it where she says, hold on. Is this one not going to search because I don't have it open right? Weeks. Where is it that she said, if you guys can't try this in 3 weeks, then there's a problem with the way that you're doing it or something like that? I wanted to read it verbatim. I can't book into trial when I've already told the jury this is what the dates are going to be. You have a remedy. You guys remember what I'm talking about? Sleuthy was probably put to sleep by Lolly today. Hey, Laundered Amber. Y'all should hop on board with my theory that she's got Odin tats under her underwear. Which is why she won't recuse. Four Pitbulls, what are you talking about? Political agenda should not play part in court. I'm trying to go back up to see what you said because I must have missed it. I don't know what you're referring to. Yes, put everything on the record. No shit. I hated when they were doing that. And now they won't even talk to each other at all. So I guess nothing's happening off the record. And now they won't talk to each other. And everything is being and then they were emailing each other because they wouldn't have these private conversations. So now these emails are becoming part of the court record. So now Gull's like, I'm not even going to have those conversations with you. I allegedly innocent. I was thinking she's like the room mother for the Owens men. Maybe she is. The trial transcript was one. It was in that one. If this is not the same one, yeah, I don't remember. I thought it was this one, where she like goes on and on about. Yeah, I thought it was this one, but it's okay. You guys know what I'm talking about. So, hi Travis. The judge said something in the hearing about there should be no problem doing a case in 3 weeks. Yeah, I just don't remember exactly what she said. I was going to try to find it so that I didn't misquote her. It's hard not to compare the 8 weeks afforded to the Karen Reed trial to the 2 weeks Gull's given to this one. Maybe she had cruise tickets booked for early June. Well, according to her, no. She would have done it out until June 14th, had she known. Had she known it was going to be an issue. I know that I was like, it's probably why I went with Delphi tonight instead of Karen Reed, because I was done. Do you not think that MSM newscasters get paid for bringing the news? Why should a podcast YouTube be any different? Well, it won't be, because I literally put so many hours of my day into this. And if you wanted to know how much I made per hour, you guys would think, what the hell are you doing, Teresa? This is a waste of your life. Let me just tell you that. It's after she sets the October, November dates. Okay. Let me go down here. I don't even think it's necessary. I just didn't want to misquote her when I knew that it was I knew I wasn't going to say it right. See, now, so before he was asking for 2 weeks. Now this is when he says it. I knew he said it somewhere. That now they're asking for 15 days, which would be, that would become 3 weeks, but not additional. I've hung people in less than 3 weeks, is what she said. Oh, Mandy, thank you. All right, well, we'll just go back over. It's in there somewhere. That's public anyway. If anybody is looking for those transcripts and you can't find them, if you go to the live where we read through them, they're in the description of each video, so they're accessible to everybody anyway. So, oh, Oz, thank you very much. That's very kind of you. Thank you. I remember that it was a condescending comment. Yeah, I just didn't want to misquote it. Page I had up, like line 20. Okay, hold on. I probably already passed it. All right, let's go back to this one. Another creator admitted getting sent the crime scene pictures. So when is this leak ends? There is no end to these crime scene photos. I'll just tell you that. Hunting Evil. They're out there. They're not going away. Many people have them. There's no. They're not going to go away. People are going to continue to share them. And since the issue is with law enforcement not actually giving a shit and not ensuring that anybody actually deleted them from their phones and just saying, hey, just can you delete those for us? That's where it starts. And now everybody knows that nobody cares from the law enforcement side, that there is no repercussion for it. They have to go on their moral standards. And if people are sharing them everywhere, people are sharing them everywhere. There's nothing any one of us can do to stop it. There was the threat of legal action, and now there isn't. Yeah, Jen, no, just 2 times speed is your friend today. Thanks, Jen. Oh, you're welcome. You're very welcome. And like I said, the last 2, you guys contributed so much of the last 2 of them. We're already in like a reserve for when we do need more transcripts. We're at that point. So. I want to give you watch time, but I don't have the heart for more corruption today. Aww. Wally and his merry band of idiots have broken me. Well, at least today, even though today was boring, Wanderer, at least he's fine. This is what should have been done the first couple of days of trial. The problem now with the Reed case is that they had 5 weeks of just crazy McAlbert stuff, and it was intense, and there was some very rough moments to watch and get through. And now we're back to the redundancy of what is typically the beginning of a trial, where they actually have to go through the process of putting evidence in for the jury to see. Think about that. We're in week 6 and we're finally seeing actual evidence in this case, not evidence that proves anything one way or the other. So what I was going to make that comment was, somebody had mentioned with the Reed case going 8 weeks and this one only going 2. I would definitely go somewhere in the middle of that, because I am a firm believer that Lolly did not need all this time that he has taken. He is completely repetitive and asks so many of the same questions. Did you guys see the things that I made? I'll have to do that on the Karen Reed live. I'll show you guys what I made. I did put them on Twitter though. Not sure any other mods are in here? Okay. All right, behave yourselves, people. She was like, Lolly, you need to speak up. She said it 10 times today. All right. We read that. The court is not required to give equal time. That's true. They're not required to do that. Timeline on the calendar was insufficient. They should have known. Counsel accused the court of engaging in extrajudicial activity, and counsel is correct that on July 9th of 2023, the court commented on a Facebook post about a softball tournament her granddaughter participated in Delphi. The court did not attend the tournament, but did say congratulations to her former daughter-in-law's post about their team winning the tournament. If counsel's allegations in this part of their motion are well-founded regarding a potential witness's alleged social media activities and are presented to the court for ruling, the court will rule accordingly. Concerns about rulings are not reasonable. Anticipatory, stupid, are not reasonable. I struggled with this one too because it's not like she just commented on a random post. I mean, it was her granddaughter playing. And I know a lot of people, and I'm not the biggest Judge Gull fan, but I still think that she can comment on her own granddaughter and tell her granddaughter congratulations for winning a tournament no matter where it is. Hi, Helen. I emailed you the email chain and the trans. Thank you, honey. Thanks, Johnny. I don't find this to be nearly the issue that I know a lot of people do find it to be. But like I said, everybody has the right to their own opinions, and I respect other people's opinions and expect for people to respect each other. So I don't think it's a big deal that she says congratulations on her own granddaughter's tournament, no matter where the tournament was. Yes, she should have thought to just send the text, like send her daughter-in-law or her granddaughter herself, if she had a phone, a text instead of putting it on social media. But I also don't think it's the end-all be-all to whether she can be fair over a trial. Defendant asserts the court has denied reasonable requests for funding. This is incorrect. Counsel is well aware of the amount of funds the court has authorized for the defendant. The court has requested the defendant to submit proper invoices and bills for Carroll County taxpayer funding. Invoices which have been submitted without appropriate documentation have been returned. I questioned this when they put that in. How do we know the proper procedure? Do they know the proper procedure? Or is this just another, they have no idea because she's asking for it a different way? That we don't know. The bill counsel refers to for $26,000 for investigative services from June 4th through October 16th was in fact returned to counsel as no documentation was provided for services. No documentation was submitted until quite recently. With that proper support and documentation, the court authorized the invoice for payment on May 17th. Okay, so hopefully that's taken care of then. Defendant complains that the public confidence in this case has eroded. As counsel should know, criminal cases are tried in a court of law and not in the court of public opinion. An independent judiciary requires that judges decide cases according to the law and facts without regard to public clamor or fear of criticism. The court continues to receive ex parte communications from the public criticizing the court both personally and professionally, and threatening the court with bodily harm and injury. What? Doesn't she make all of those public? I don't recall seeing any that are threatening her. Is there other ones that we don't know of maybe? Hi, Dan. The court continues to provide these communications to the parties. Has anybody read one? I stopped reading most of the more recent ones with the hamburger people, and it was just ridiculous. The court is not interested in memes and other social media content that can be easily located on the internet. The court cannot be swayed by inappropriate and ridiculous outside influences. This is probably the most coherent, cohesive paragraph she's actually put in here. Like different person wrote it almost. Yeah, I don't remember. I didn't see anybody threatening her. Really believe that her refusal to step aside makes the rest of her remarks moot, though her misstatements in this finding will certainly be included in the next writ. There's too much bias. Right, and there's a lot of inaccuracy. There's things in here that like now have the transcripts of that we know she's not telling the truth on. The whole thing reads like as she starts taking them, she's writing more. I imagine, if I had to take a guess, I imagine we're going to see another original action. That's where I'm at with it. Defendant further claims that the court has refused to order the state to comply with discovery rules. The court has set defendant's motion to compel and motion for sanctions for hearing, which has been continued due to the filing of this motion to disqualify. She keeps putting at him like, you guys literally just wait. All these things that you're complaining about, you've now wasted more time by putting this in, and we could have handled all of this now. Now I think they're all just doing it. Nobody wants us to go to trial. They're all just like, nope, just keep pushing it down the road. The motion for sanctions hearing, which has been continued due to the filing of this motion to disqualify. The previous defense motion to compel was denied without a hearing as it was unsupported by evidence. Defense counsel alleged bias by the court, only allowing cameras in the courtroom on one occasion. The court has not allowed cameras in the Carroll Circuit Court due to its limited size and its layout. The court did allow cameras in the Allen Superior Court at the hearing conducted on October 19, 2023. The hearing was not conducted and the media outlet providing pool coverage did not comply with the court's directives regarding coverage and broadcasting of the proceedings. The court lost confidence in the ability of the media to cover hearings appropriately. Wow. That is so ridiculous. She gave them orders that they could go, was a half hour, what was it, a half hour before and a half hour after the hearing, I think was what it was. Now I'd have to go back and even look at the court feed from the October 19th one, Lynn. The one, she got mad because they were recording when they were still in chambers, but she was late to the hearing. So they had started recording according to the time, and she didn't like that they were going and doing it that way. I'm like, okay, somebody in here who's local, correct me if I'm wrong, but I'm 99% sure I'm right. Carroll County Circuit Court actually has cameras in the courtroom already. It doesn't have to be an outside, it doesn't have to be a court TV or a pool camera. I'm pretty sure they have cameras inside their courtroom. And I'm almost positive that I have somebody who was local who was nice enough to send them to me, and I don't think I saved them on my computer yet. An original action, that's what they called, it's the writ of mandamus. It's what they send to the Supreme Court to see if the Supreme Court will look it up, like will look into it for them. So it's called an original action or a writ of mandamus. They have cameras. They're like Judge's cameras or Judge Boyce's cameras or Letitia Stauch's cameras. Yeah, it's like an online thing where you can do it that way. I think the Carroll County Courthouse is already set up with cameras. Yeah, I just didn't know any of them were threats. But that's because, like I said, I stopped reading them, so she could be right. That was a great comment by Gull, to an extent. She is referring to those crazy-ass emails people keep sending her, disappointing that she acknowledges she is reading them. That's true. She'll have the backing of the Supreme Court on all of that. Agreed. I agree. But people who write to the judge, I get that they want to write and say, like, I'm an Indiana resident and I think we should do these things and this is how it should be. But the people who write the really weird, crazy shit are the reason that we can't have nice things, and that makes it so that the other people shouldn't write either. But just think back, like, how did this all start? Why did people think that it was okay to start writing to the judge to begin with? Like, the judge never should have put any of that stuff out publicly, because it became a a way to communicate with other people on social media. And it got very weird very fast. Rexy, oh, did you? Oh, thank you. Sorry, y'all need to get over it. You are not getting cameras to stream or even audio recordings of the trial unless someone makes Indiana open records requests for copies of the tapes well in advance. That's what I'm saying. So she's now saying that she doesn't think that she's lost her faith in this or her confidence in the ability of the media to cover the hearings appropriately. Well, that's one of the reasons that like Judge and Judge Boyce they don't have a pool camera in there. They literally just have it set up. It's stationary. You see the same thing the entire time. So she would have control over that. So for her to say like she doesn't want a media outlet doing it, okay, perfect. That's right, Chelsea. The court has issued adverse rulings against the defendant as well as against the state of Indiana. Adverse rulings do not support a reasonable bias or basis for questioning the court's impartiality, nor are they grounds for disqualification. They are just adverse rulings. Travis and I think we talked about this one time when he was up here, because it's not the rulings that are going to create the bias or show the bias to the Supreme Court. It's her actions and it's her words in her orders. And the way that she spoke to them on October 31st at that hearing, when they tried to go in and they were going to represent Richard Allen pro bono, and she was like, there's no way, I cannot allow you to do that. Like the incompetence and all these findings that I have is a problem. Like, we're not going to do that. And so then, Sniper, I've been so worried about you. I knew that you weren't doing great. Hold on, let me see. Hi, Sniper. No, you are perfectly fine. I was just very worried about you. I'm just so happy to see you. For 2 months? Oh, God, I'm just so glad that you're okay. I am so glad that you're okay. Aw, I was very worried, and I was like, I don't even know how to get a hold of you to, like, make sure you're okay. I'm just happy that you're back. That makes my heart happy. Okay, hold on. Dan asked a question up here. Dear Judge Gull, I'm very disappointed you haven't mentioned me. It's seriously affecting my clout online. Well, I think like that's why I said I get why people, especially people who live in the state of Indiana, want to like be heard and reach out and be like, come on, like listen to us. But it's the ones that are fucking weird. And then she puts them all in the same pile. The nutters and the weirdos will now have to attend court rather than sit at home and back at their TVs or radios. Dan, I may have missed what comment you're referring to. Yeah, that's what I was thinking that she had. Aw, see, people are thinking about you, Sniper. Yeah, TVIs kind of suck sometimes. I'll send you an email soon, but yeah, I'm good to go again. Okay, I'm just like I said, I could have cared. I just was so worried because I know that you had said that you'd gone to the VA, and then I didn't hear from you, and I was like, oh no. Yeah, there's only like 100. I heard less than that. I heard less than 100. I'm thinking if we look at Karen Reed's courtroom, I think it's going to be probably very similar to that. It's going to be family and then like 3 seats for like the public. I'm one of the nutters. No, you're not. I think a letter to the clerk of court recorder that want the audio from the last hearing and plan on making requests for daily copies during the trial would do it. I can message and ask, but I don't know. I'm at the point where I don't think what we think we're gonna see right now for this trial is not what I think we're gonna end up actually seeing. So, but when it comes to the rulings, it's not the rulings, it's the way that she talks about them. And in my opinion, I think that the order, when it came to the contempt, where she puts her personal feelings about them in the order that had no legal bearing, I don't know how they're not going to be able to use that. Would Carrie asking possibly change her mind? Oh yeah, there are way less than 100. I would encourage citizens of Allen County to pay attention to their ballot, and when it asks if Judge Gull should remain on the bench, to vote accordingly. Yeah, you'd think so. Sorry, I was here at the beginning and closed my eyes. How much have I missed? Oh, Simon. The whole thing almost. I think yeah. We just finished reading it. Sleuthy's probably sleeping or busy doing something, because that fucking hearing today was, or the trial today was just so bleh. Need to get some, I love me some tie-dye. Carrie might have some weight on her having cameras simply because she is family, but the only problem of that is that cameras are not legally required. So ultimately what a lot of judges do that don't have cameras in their courtroom, they will have a feed that goes to victims' families that can't physically be in the courtroom. But not always. If you're physically able to be in that courtroom, they typically just say, hey, we have a spot reserved for you as a family member, and you're welcome to be here any day that you want, but that's the extent of what we're going to give you. But some judges, it could sway them, but legally has no bearing. Well, I think my opinion is we're going to see another original action, and they're actually going to focus more on the bias than they were able to in the last original action. That's where I'm at with it. I don't know. There's no way otherwise, I'll tell you right now, if they put this in and they don't push any further with it, then I'm going to agree with all the people who are like, the defense just did this so that they could push out the trial because they're not ready. If they don't follow up on this, because there's no way they put this together with the expectation that she was actually going to disqualify herself. There's no way. And they're like, oh, too bad. She said no. I guess we're just going to have to keep her. If that's what they do, then I will absolutely believe that they simply only did this because they weren't ready to go in May. Because there's no reason that they would just expect that she was going to step down. I think she ran unopposed the last time. See, we looked into that a while back, but I think she was appointed and then elected, if I remember right. Yeah, cameras in courtrooms are still a relatively new idea here. But I think Hurd's like with that. I don't think that October hearing should be the end all be all to her decision on the cameras. And her doing that is what makes people think that she simply only let them in there because she knew what she was going to say, and she wanted to embarrass them. They've asked for audio only. They've come in. The Media Coalition asked for audio only, and she denied it. She's denied every request for camera and audio. And then she says she's doing it because the Carroll County courtroom is so small. But that's problematic too, because like I said, they already have cameras in there, so you don't need to have like a pool camera in there to be able to stream it. The other thing is she's had other hearings in Allen County that they have requested cameras for, and she's denied those. Christy, I thought she would step down. She wants to preside over this trial. She does. She just is like, I'm not letting go. I'm gonna be here for the whole thing, and you guys are just gonna have to deal with it. And if you don't want to deal with it, then you can leave. I'm hoping that we can. I know that with the Vallow case, when Lori Vallow went in, they didn't have cameras, and East Idaho News, I think, purchased the file daily. I think a couple people actually purchased it daily, and it was like a couple $100 a day. That's kind of a lot. We'd have to pull some multiple creators to make that happen. Osbrook mentioned on a panel I was with him on that I hope they don't just get the transcript, but also request the recordings of the hearings because of their tone. Oh, and AJ was saying that when we read that last one, AJ was in the courtroom that day. She's like, yeah, I wish you guys could hear the way she was speaking to them. She's like, it was like cringy. She's like, you guys can't hear the way that things were happening. So hopefully they do get the audio. The motion to disqualify was also to make a record. Right, but if they don't do anything else with it, it's still problematic. In the historic trial that ended last week in Manhattan, the media arranged with the court reporter to provide daily transcripts. I would be crazy if they put together a actual daily transcript with no audio. I don't know how to do that. I'm sorry, I can't stop yawning, guys. The small courtroom is exactly why they need cameras. Oh, I think so too. They shouldn't. That little town is just going to be overrun. And how many more people would not be actually physically going to that trial if they could just watch it online? So why did the defense do now to get rid of her? You may have already answered this and I missed it. This would be the original action to the Supreme Court, which they've already filed 2, so it would not be a surprise for them to file another. Or they can file for an interlocutory appeal. The problem with that is they have to actually get the interlocutory appeal has to be granted by her, essentially, or it's denied by her, and then they have to take that to like the appellate court. I think would be the next step on that action, and that would be problematic because now we're talking pushing trial out even longer. I imagine you'd see another original action would probably be the next course because of the backing of some of the attorneys in Indiana. I think that's more their expertise anyway, and I think that's probably where they would go. What do you guys think? What do you guys think is going to be next? Now you got me do it. Sorry, rambling. It was Lolly's fault. I'd never wanted 2 times speed so bad as I did today watching the Karen Reed trial. I just feel like you're doing nothing wrong. Why would you not want cameras? I can see that they become like having the pool cameras kind of become a hassle, especially if you do end up having any type of, minors that are testifying. I mean, like we kind of have that issue in the Karen Reed case, but they just shut everything off. We had that issue in Zachariah Anderson's case, and I thought they did terrible. The other thing about having the cameras in there is just that if you physically have a pool camera, it is the size, it is the amount of space that they require. And if you have a courtroom, well, I mean, shit, I don't know. Karen Reed's got it. There's literally no parking but the spots around the building. Yeah. Audio recordings are always better than written transcripts. Oh, yeah, I agree with you. They do dailies with a real stenographer with a stenographic machine. I've done trials where we even paid for real-time transcripts. The stenographer is how they do closed captioning on TV, on live TV. That explains why there's so many mistakes. Here in Ohio, we had the Pike County where, oh, yes, you did. And it was so weird because they allowed witnesses to opt out of being live streamed. Yeah. Yep. Ives expected Jerry Bean to take over his job. How did McClellan sneak his way in there? I don't know, but it's interesting that he has the same financial supporters for his campaign, his quote-unquote campaign, as Shane Evans does to be judge, and Tony Liggett did to be sheriff. That's from locals, so maybe look into that. The motion and lemonade. Park at Riley Park, at Canal Park, park at City Park, and enjoy the walk. Yeah, that's not too far. Or you know where else you could park for, Pitts? You could park at the old Farm Bureau building. Sorry, I had to. Jerry Bean was also a judge. He probably had the same financial backing as Mike Thomas. The people are paying. We are the boss, period. The taxpayers should be. But, you know, that's not how it always works. The daily copy should be available for the lawyers during trial. Yeah, the unofficial ones. I think that's what Travis was saying too. Like the unofficial ones that have all the typos. When I was in New Hampshire for Harmony's case, the camera guy in his setup didn't take up but 1.5 seats on the bench. If that much, he sat right underneath his camera equipment with a laptop. Aw, you were at Harmony's. That's right. I forgot. Poor little Harmony. Her little glasses. The motion in lemonade has been denied due to the lack of chinchilla of evidence. They should probably get some, what are they, stop and save bags? Shop and save bags from Massachusetts. Places to store their evidence. Kay says, I'm not too sure they would look favorably on the defense submitting another original action, particularly on an issue that's already been in front of them. Well, the problem, though, Kay, is that the first one, even when they were arguing in front of the Supreme Court, the justices were like, okay, like, so do you want to like talk about this part? And because they had only a certain amount of time, right? They had like a half hour, 45 minutes each, 40 minutes, I think it was each. No, it was 30 minutes because they normally only have 20. And I think it was Lehman who said like, no, getting the attorneys back on is the priority here. So they didn't even really get to argue what they had, not to mention they have more now than they even did then. I don't know what'll happen. Shop and stop. There you go. I fell in that hole about 6 months ago after I let it go for so busy with life, and then I couldn't get enough. Yeah, don't do that. Well, plus, even if you parked in Gull's driveway, she lives really far from Carroll County Courthouse, so that'd be really bad. He wasn't always done it. All right, well, let me see. All Eyes had said that she emailed me that part, so let me pull that up really quick. Oh, man, I haven't been on my emails for a while. I need to get back in here. I got you. I got you. Page 23. It's this one. If you can't try this case in a month, gentlemen and lady, that's right, that's when she said, and lady, there's something wrong. I see no reason that this case cannot be tried in 30 days. We will work on Saturday. We will, the schedule that I've previously provided to you in an email some month ago, I see no reason that that can't happen in that time frame. It says, good afternoon. Judge Andy and I wanted to touch base with you before the end of the work week. This is from October 6th of 2023. The issue revolves around the possibility that some of the crime scene photos have been leaked, so to speak, and are in the hands of the public. There's most certainly a photo of the F tree that is floating around. The photo itself is not overly disturbing. Is this the same thing? Am I reading? All Eyes, are you still here? Hold on. I guess I should come back over here. Yeah, she was addressing the defense only. That's the problem with that statement. Well, yeah, because she's not saying ladies. In her first time, she says something like that. She's like, ladies, because it's got Diener too. And then she changes it on this one. She's like, gentlemen and lady. So she moves the goalpost and is still snarky. Correct. That's essentially what she does. Because in that email, she's like, no, you guys don't have that. You guys don't need any more time. You don't have what you need to have more time. And they're like, well, you haven't given us any of the hearings. It's just like, fine, you want a hearing? We'll have a hearing on May 7th. And then they go have a hearing on May 7th. And she's like, if you guys would have just told me that you needed more time, I would have scheduled it that way. And then we look back at the June 15th hearing from last year, and he is saying 3 or more weeks. And she's not saying, well, if I put it 3 weeks, that's it. That's a firm ending date. I don't know. Like I said, I mean, I don't think any of us are surprised by her actions. I don't know. That's why I said at the very beginning of this live, I said I'm just so frustrated with this case because I just feel like justice is so far away. It's just so far away at this point. She does have Jennifer Auger on here, Auger, as an attorney for the defendant. Prosecuting attorney, Nicholas McLean, deputy prosecuting. So. I know. Well, if you told me you needed some more time. I'm like, no, that's not what you said. Literally, when they did tell you they needed more time, you essentially said no. I don't know. Maybe she's like off her meds or something because I just don't get it. And I don't know why she's so adamant about being on this case. Yeah, not to mention the voluminous discovery that keeps rolling in. But then she's very condescending about that too. She's like, well, I had a hearing set to talk about that, to talk about your issues, but, I had to cancel those because of this motion. Like, you're the reason we're not having them. What happens if they go back to the Supreme Court and they leave her on a second time? Then we have trial in 2025 probably. Which is kind of where I think we're at. I don't even know if we're going to have a trial in October. I have no faith in any of this right now. This case, hi, Dean. I think you said hi earlier when you popped in. I don't know if I said hi back to you. This case is her retirement book deal. And it's funny because a lot of people will say that about the defense, and they act like judges and prosecutors and court clerks now have never written a book based on a trial that they took part in. Like, if you're talking about a book deal, you could talk about any one of these people. You're talking about interview money, you could talk about any one of these people. I have beef with old people. Yeah, I have a beef with old people off their meds. All of a sudden, I'm against. OMA just says fuck because they can do so much damage and not face repercussions because of their work experience. That statement's not funny, but it's just the way I read it. She's like, I got a beef with old people now. They would not take it if they play. Well, they take it and then just deny it. They just say no, we're not gonna do anything with it. Oh, thank you, Mother of Dragons. Travis says it was pretty disturbing how she was rattling off how quick her trials were in a very serious cases, making one think they didn't get much, if any, defense. She didn't realize it. No, I think somebody said earlier like that her flex there was not a really good look at all for her. She did not realize what she was doing. I mean, because if you look at like these other cases, like look at how much these judges just give and give and give. Look at Judge. Travis, you watch those with me. Judge is so giving to Ann Taylor and her defense team. And it's like, what else do you need? Do you want to come in every week? Do you want to, Do you want to have like meetings? Do you want what else do you want? You want me to have more in-camera hearings? Like what do you need me to do? Like anything he can to make sure that Brian Kober is getting a fair trial, and that she can't have any complaints that he didn't do what he was supposed to. Almost to the point where it frustrates people because they're like, Judge, you need to make a fucking decision and stick to it. That's where I'm at, Mustang. I'm just like I'm so frustrated. I just don't know. I don't know. I have no idea what's going to happen. Also, I would not begrudge the defense if they wanted to write a book because they are getting paid only $100 an hour. Yeah, Ann Taylor's getting $200. Helen says, I just had my 55th birthday last week, and according to my grandkids, I am very old, so I will need to get meds. Don't let Hammy know. Hammy's got big beef with the old peeps right now. Helen, I'm 52, and honestly, my son asked me not long ago if I went to a one-room schoolhouse and was freaking serious. Oh shit, that's funny, Susan. It's just sad that they're all behaving on this manner. The girls and their families deserve justice. I totally agree with you. And it's like we can't get anybody on the same damn page, except for, ironically, the Supreme Court justice who's like, this trial needs to get back on track. Like, we need to get this on track. Like, she repeated it over and over and over again. Could you imagine if they do take another original action and then that Supreme Court justice is going to be like, what are you guys doing? Fiends all, oh shit, I went to a one-room schoolhouse. My mom did. My mom went to a one-room schoolhouse. Just like she did not have the authority to take them off the case. She doesn't have the authority to approve or deny defense strategy. No, they do have some legal requirements, but I think it'll be a lot more along the lines of getting in the information by using the lack of investigation. Robin said her granddaughter asked if her friends were pilgrims. Oh shit. Anyway, you could get a handwriting analysis. Her signatures are huge on this one. Yeah, she wanted to make sure she put her stamp on that. What's the other one look like? I think it's pretty big too. Yeah. She was like, this is me. I am Judge Gull. All right, you guys. I'm going to wrap. Hold on. Did I see that somebody else had a live? Let me see real quick. No, that's... Oh, yeah. He does have one. All right, hold on. Let me go fix this real quick. Let's go. We can go hang out. Doc drop and review with talking about Judge Gull rules on the motion to recuse and gives this legal analysis over with Bob. Let me go set that up. I'll send you guys. We can portal over. He starts in like 5 minutes. Look at that. That's good timing. I just got to set it up on the back end. That's good though, because I need to do the Karen Reed recap, and I just don't want to. I just don't want to. Here we are. All right, that'll portal us over to Bob. Oh, thank you, Dean. Mustang Lolly. You better slow your Mustang down. I always just think like he's just lollygagging around, and today was no different. Today was no different. I was like, this is even worse than normal. Even Judge Bev's like, Lolly, get your shit together. Get your shit together. We can't hear you. You're going to make us turn off the air. And I literally, as soon as she's like, all right, that's fine. We're just going to turn the air conditioner off. I was like, ooh, that jury's going to be so mad at Lolly because he knew he needed to speak up and he just refused to. Hi, Veronica. Don't do it. We can gather another day. Yeah, I don't want to. That's why I'm like, I'll do it tomorrow. We can do it tomorrow because there's no trial. Oftentimes, just saw a pic of Garrett Kurtz. He looks so much like the second sketch. He absolutely does. I know a lot of people who really suspected Garrett Kurtz of this crime for a long time. The problem with these damn sketches is I have put them side by side, compared them with so many different people over the years, and they just are so similar to so many people. It's like they don't have that like distinguishing factor. So when people are like, yeah, it looks like Richard Allen, I'm like, yeah, as well as it looked like 15,000 other people over the last 6 years. That's where the problem is with the damn case. And that's why nobody recognized who this person was. All right, I think I got all. Let me say some double thank yous. Oz, did I say thank you? I think I said thank you to Oz. Dean, thank you. Mother Dragons, thank you. Rexy, 13 months. MK, thank you for gifting those memberships again. Francis, thank you. And Teresa and Caitlin, thank you for being members for so long and supporting the channel. I do have some other cases. Before I got sucked into Karen Reed while I was still doing Delphi, but not trying to double up on these. I have some like one-off cases that I want to talk to you guys about. I figure I'll just do it. We can do it like members only, and it just be kind of like chill, and we can kind of research some things together. Like, are you guys familiar with this is probably the right age group, I would say, The Land Before Time? And did you know that the little girl who was the voice of Ducky was killed by her father? Well, I learned something recently about that. So she was killed by a family annihilator. Did you also know that she played Kimberly in Fatal Vision? And if you don't know what Fatal Vision is, you got to go watch my Jeffrey McDonald documentary. Fatal Vision is the story based on Jeffrey McDonald. Yeah. So she played Kimberly in a show about family annihilation, and then her dad killed her in a family annihilation. So like just things like that. I'm going to kind of talk about just some like off the cuff stuff that's still true crime, but not like in the depth of like what we do here. No, I don't think I know that. I did know that for sure. Yeah, I didn't know that. I knew the story about her, but I just realized that she was actually Kimberly from Fatal Vision. So I think we're gonna, once this Karen Reed trial is over and I am back, at the end of this month, we have gymnastics nationals that we've been, if you guys aren't aware, we have been raising money for on the GoFundMe for Kaylee to go to nationals at the end of this month. So we will be there for about a week. And I figure when I get back, Karen Reed should be done. We may have another trial on the horizon that I want to cover. And obviously we'll have updates on Delphi throughout, but I'm going to go back to members only lives, probably Wednesdays like I used to. But I think they're just going to be more chill, like just kind of talking about different crap. Not that these aren't chill, but you know what I mean. All right, so I'm gonna end this. He starts in like a minute. This should portal you guys straight over to Bob. I will see you guys over there for a hot minute, and then tomorrow we will hop on and talk about, did I meet the goal for my fundraiser for my daughter? No, it's pretty expensive trip. So it's just anybody that would like to contribute and help out. Because it's nationals. It's like a week-long whole shebang, and you know how that stuff goes. So I appreciate it. There is a documentary I cannot recall or cannot recommend enough, The Truth versus Alex Jones. It is much watched for true crime because of the parallels with cases with conspiracy. Oh, perfect. All right. I'll see you guys on the flip side. Thank you guys for hanging out with me. I'll see you at Bob's. Bye.
Do you dare to follow me down? Head into the unknown. stops, no